and thank you for being here today. My name is Yolanda Fair, and I'm the project attorney with the Office of the Juvenile Defender. And I'm very grateful to have three speakers with us today to talk about raising race in juvenile court. As the years have gone past, we know that there is inequity in the juvenile justice system. I know many of us observe it in our daily practice. We've seen the data in the numbers. And today we really wanted to focus on some practical tips that we can do as defenders in the courtroom. Um, the speakers that we have today practice in different communities throughout the state and have very different experiences. And I'm excited to hear what they have to say about ways to address race. I'm going to go ahead and introduce them, and I'll start with Wadrina Baker-Harrell, who is the Chief Public Defender in Orange and Chatham counties, that's Judicial District 18. She's been practicing law for over 20 years. She graduated from the North Carolina Central School of Law in 1994. In her time in the Public Defender's Office, she's represented both youth and adults and has kept the youth defense a part of her practice. She has a real passion for advocating for those who are marginalized, those who are indigent, and has really devoted her entire career to representing and assisting indigent individuals. She served on her local JCPC as well as her judicial district's racial justice task force, and we're excited to have her here today.
Thank you. I'm excited to be here.
Thank you, Rodrina. We also have Michelle Dupree, who is the director of the Children's Defense Team for the Counselor for Children's Rights in Charlotte, North Carolina. Michelle has been with them for, I think, over 5 years now, but she is from New York. She went to Albany Law School and graduated in 2008. She practiced for 7 years as a trial attorney in the Juvenile Rights Practice section of the Legal Aid Society, and then also 2 years as an appellate attorney with the same organization. Again, she has spent a good portion of her career, most of her career, representing youth and being involved in the youth justice system, and she's been a tireless advocate, and we're excited to have her as well. And then last, we have Leanna Hunter. Leanna Hunter is an assistant public defender in the New Hanover County Public Defender's Office in Wilmington. She is a 2001 Howard University School of Law graduate and has been working in juvenile justice and defense since 2007. She joined the Public Defender's Office in New Hanover County in 2010 and has been there since. She serves as a member of the Criminal Justice Advisory Group in her county, the Juvenile Crime Prevention Council, and she has just really devoted her career to representing youth in both juvenile court, but also in the DSS world as well, being involved in that system. She has trained defenders in our state and on various topics here and with the School of Government. And again, we're very grateful to have her here today too. So without further ado, I'll go ahead and get us started. And just for some housekeeping, we have a set of pre-planned questions that I'm gonna go through the speakers with. But if you have any questions at any point, please put them in the chat. We're gonna try to save some time towards the end for audience participation, audience questions, but please put them in the chat. And Nani and some of the other team members are working on gathering those questions for us. So I'll just get us started. Again, thank you guys for being here. I'll start with you, Adrina. If you could just tell us some of the practical ways that you address race in your case. If you can talk a little bit about how you do it in court and the different phases of the case.
Practical ways. I start off with just looking at the case itself, trying to identify who the parties are, start looking at who identified my client, if it's a cross-racial identification, because that can play a part in whoever identified my client. The next step in the practical ways, just really sitting down and talking to my client to find out, how did you end up here on my caseload? What's going on with you? And just generally looking at the situation first to even determine if race is an issue. And then once I determine that it could possibly be an issue, then start trying to investigate the different ways it plays a part. Identifying my client, just biased by the school resource officer, biased by the principal, the teachers, or if it happened at school, or maybe the neighbors, whatever little tiny ideas that could be there, I try to investigate to try to rule it out. And if I can rule it out, then I move forward without bringing race up. If I can't rule it out, then I leave it as a potential part of the case that I have to explore some more.
That's helpful. Um, I'm gonna pass it to, I'll give everybody a chance to respond, and then I may interject some questions. But Michelle, how about you?
So I generally start from a perspective of more than likely racial bias is involved at some point in most of my cases. Being in Mecklenburg County, I think we're at about like 95% of our clients that we represent are children of color. And so starting off from that mindset really allows you to be reviewing your case, whether it's detention or whether it's at filing stages, whether you're looking at suppression issues through that lens of where are we and how did we get to where we are? And so some of the ways start off as early as detention hearings. So for example, we have had cases with young people who have had behavioral issues at school that have been escalated to the point of being charged with assault or being charged with making threatening statements. And a lot of times we're seeing those come out of significantly predominant white schools. And so one of the things that we do is we look at, okay, what is the demographic in that school? And you can pull that information up before a detention hearing, know what that demographic is. And then you can also even know who the interacting person with that client was, whether they were white also. And so there's a lot of times that is incredibly beneficial if you're then turning around and arguing at your detention hearing. And I get to say, you know, my client is at a predominantly white school and the person that escalated this looks like me. Right. And that allows for that narrative to start as early as the detention hearing. It allows the state to start hearing it. And then you can kind of keep pushing from there as that case progresses through. And I think that a lot of times in terms of raising race, the earlier you're looking out for it and the earlier you're pursuing it, the better off your results are going to be.
Yeah, I would agree with that, because you can start to kind of dig into both your client's history, but the history, kind of get that into the court minds early as well. Liana, how about you?
Thank you. I think a lot of the ways that have already been mentioned are definitely things that I do. I need to be better about incorporating numbers because I do think that can be pretty persuasive. I would say that in court, you know, motions to suppress, just stating the reality of certain situations out loud in the courtroom. I think a lot of times there's like an elephant in the room and everyone kind of knows that there's an issue that's around surrounding race and people are hesitant to bring it up or don't know how to bring it up. And so I have conversations with the prosecutor. I've done that many times. I look at, you know, facts. Sometimes just reading a petition and I already know that there's something fishy about it. And I see, you know, fortunately all the information is provided about our clients. And so from the get-go, it's on my radar that that race could be playing a role in this, especially as it relates to charges like disorderly conduct or assaults in school, simple phrase. You know, there's some that I look at and I just know that that's an issue. So I have pretty candid conversations with the prosecutor. The prosecutors overall, I would say that I've worked with here have been pretty open to that. You know, for instance, I had a case where my client was wearing a jacket, like a heavy winter coat, and he was hanging out outside with his friends. And it was like he was wearing a heavy coat and this, you know, and I'm like, it was January. So it's pretty cold in Wilmington in January. So like the facts that they were using did not make sense for why they stopped this group of people, except that they were, you know, three young black men standing together, hanging out, and then, you know, God forbid. So, so I think we just can't be afraid to bring that up and just have those conversations with the prosecutor. I will mention it to the judge at secure custody hearings. As much as it is related to my case, I'm going to bring it up every step of the way. I also mentioned it to DJJ. And when we were kind of preparing for this, you know, I think a lot of times bringing that to someone's attention I'm not saying that it solves the problem, but they see that it doesn't look good. And so that might make them pay closer attention to what they're doing and how they're making referrals. And so it doesn't really solve the problem ultimately, but it may help reduce the impact on some kids that are not going to get, that referral when they would have before had we not brought it to their attention. The same way that, I look at where the referrals are coming from, looking at SROs, the teachers, we had runs where there were all these kids coming from a particular teacher's class, and they happen to be primarily people of color. And then I've had the opportunity to see another situation where it was not a child of color, and the way that it was handled and framed was completely different. Describing the behavior, there needed to be some kind of intervention for this child, and it was only when he really kind of went off the rails that they referred it to court. But there had been all these prior interventions, and I just so happened to have another client in that same class who's a person of color. Immediately, they sent it to court. And so I'm like, what is the difference except for race? So I think at every stage, like everyone said, and particularly before it even gets to court, while it's in court, we can bring it up.
I think Wadrina had her hand raised. Yeah, she's doing it now. So I don't know if you saw that on your screen, Yolanda.
Yes, thank you, Bridget.
I did have my hand raised because I'm going to just put it out there. Being a person of color, being Black, Michelle mentioned bringing things up or bringing the issue up early on. As African-American attorney who has lived life, I have to be careful of how early I bring the issue up, because, and I think it's a little bit different for me than for or the panelists who were speaking, is because too often white people, or I can't even say just all white people, but too often if you bring up race, people insert eyeball roll there. They eyeball roll, here you go, playing the race card again. So for me, in my practice, I'm a little hesitant to bring it up right away, because you want people to take it seriously and not just roll their eyes going, there she goes again, bring it up race. Everything is always about race. No, or they'll say, it's not always about race. So one of the things I have to be cautious of, which my white counterparts may not have to be as cautious about, is when do I insert it in the discussion? Because I don't want people to roll their eyes, saying, there she goes again, or there's just another Black person again dropping the race card, when everything isn't about race. And so there are some advantages, I think, if you are not, a person of color, of you bringing up the race issue early on. You had that advantage as compared to someone, me, being a person of color and bringing it up. And I just wanted to point that out based on your question. How do you see it, or when do you bring it up? And I think that is something that we have to take in consideration too. So that was my follow-up. Thank you.
Yeah, that's helpful, Wadrina. I think it's important to remember that our own racial identity does influence how, when we see the work, but also how we express that to the court and to our clients. That does segue to one of the questions, though, that we had, which is, how does your own personal racial identity impact this work? And does that show up in the discussions that you have with your clients? Does that show up in the courtroom? I will throw it to Michelle. And Austin, Wadrina, I will come back to you for this one too, if you have anything else to say, but I'll start with Michelle.
So I think that where you practice, so I think your racial identity combined with where you are practicing, where your practice sits, has a lot to do with it. So obviously I'm a white woman, and I practice in a courtroom, and that is predominantly Black. Frankly, our judges, 3 out of our 4 juvenile court judges are Black women. The vast majority of the time, the court counselors are Black men and women. The obviously, you know, Spencer Merriweather is a Black man, so our prosecutor, our district attorney is, so is our chief of police, so is our sheriff. And so there are a lot of times that inside of the courtroom, of the professionals inside the courtroom, the attorneys, the judges, the sheriffs, I am the white person in there with my clients. And it does change how you argue. So, you know, when I talk about, and I think Adrena made a great point, right? When I talk about raising race, that's where I'm raising race, right? And there are times that I am the first person that raises that. And I think this kind of goes, I know we're going to talk about it a little bit later on, with how you raise these issues in a way. And I think for me, I have to be very cautious of how I am raising it, given the fact that I'm a white woman practicing in an environment that I described. And I think that one of the things that if you are a white defense attorney practicing in juvenile court, you have to be incredibly mindful that you are a white defense attorney practicing in juvenile court, where your clients and their families are, or in my circumstances, are predominantly Black and brown children with their family members. And that if you are not incredibly honest and incredibly in touch with your own privilege and your own biases and all of the education that you can possibly get, you probably are going to misstep at some point. And that goes to speaking with your clients, that goes to speaking with their family members, and that goes to raising these types of issues inside of the juvenile court context. And so I think that one of the things that you first have to do is really establish that you do understand what these issues are, and you kind of get a sense of how you're going to raise it in the environment that you work in a way that's going to be beneficial and heard on behalf of your clients. Because the reality is that it does exist, but it's going to go unheard if the source of argument is not someone who the court is going to trust, or the court counselors are going to trust, or, you know, the police officers are going to listen to. And I think you have to be mindful of that when you're proceeding in any context where you're making these types of arguments.
No, yeah, I think it's so interesting because we do a lot of court visits throughout the state, and each courtroom is a little bit different in terms of the actors and things that you see. And so I think I'm often thinking about how I speak to that room versus this room versus that room. So yes, I think a lot of what I understand what you're saying, Michelle. How about you, Liana? How does your racial identity impact your advocacy?
I would say that in a lot of ways it helps me to be able to identify with my clients, and talk with them in a way that I'm not just speaking, like I'm speaking from personal experience. I will say that I think my Blackness, I don't know how another way to say it, so I'll just say it how is a little bit more digestible for a lot of white people because I'm light skinned. And so I feel like my journey has not been without experiencing racism, but it's been different from my comrades, my coworkers, my family, my clients who are darker skinned. And so my experience informs sort of how I walk about the world. I was raised respecting authority figures, so I would never get into an argument with police. I would never, you know, I like to fight the system within the confines of the law, and I have no problem doing that. But I think some of the ways in which I was raised definitely informs how I move about the world. And it took me a long time, because I've been practicing now for over 20 years, and it took me a long time to feel comfortable enough to share some of my personal experiences at the appropriate time with my clients, and also just to keep it real with them. Like, you're walking down the street, and anything you do as this brown-skinned young Black man is going to be suspicious, right? You running away, you doing this, the odds are stacked against you from the beginning. And so we're trying to prevent you from being embroiled in the system. And I'm not saying I had this conversation with everybody, but I'm kind of having this talk like the standards are different for us. You know that we're going to be more scrutinized. When you're in class and there's two people acting up, the teacher's probably going to look at you if there's a Black person and a white person. So I feel like I had those conversations with my client because I've experienced some of that, and I've had family members experience some of that. But I also recognize that not all Black people have that same experience. Some people don't have any experience with that. So I think the key to it is speaking, if you're going to share that, from your own experiences, coming from an authentic place. And it's not just because we're Black, oh yeah, we get it and we can do whatever. That's never how I would approach a situation. And I don't think that would be an appropriate way to approach it. But I do think that it makes me particularly aware of not only the big issues that we face as Black people walking about in this world, but also the more subtle things that unless you experience it, you really cannot understand it. And there's kind of a shorthand when I'm talking to parents of kids of color that I think in some ways makes it easier for them to trust what I'm saying because they feel like I'm coming from an authentic place. I will say that I also share with them experiences like me being always considered the social worker. If I come out and I'm going up to meet a client or parents, people never believe that I'm the attorney initially. That's happened in my practice in juvenile court as well as in abuse, neglect, dependency court. There's like the surprise that happens, and I share that too. And so I definitely believe that our racial identity, whatever it is, will inform how we move in this work.
Yeah, I like that. I think it's important, whatever race our client is, to realize that folks aren't a monolith in whatever race that they are. And, I think sometimes we have a tendency to group people together, and it's important just to remember that our client's experience could be similar to ours, it could be different from ours. I mean, just because we are a person of color, Black, a woman, any of those things, just to remember that they have a unique experience. Audrina, did you have anything else you wanted to add to that?
I would just add that when I speak with my clients, in particular their parents, I like to remind the parents that I am a mother. I have 2 sons, and that some of the experiences that I've had with my children and my fears of my sons being stopped by, police officers just because of the color of their skin, that gives me an idea of what the parent is sitting there feeling, and try to take it from that perspective. And it allows the parent to open up and give me a little bit more insight as to what their child has experienced, especially if it's something at a school. I'm in Orange and Chatham County, and let's talk Chatham particularly. Chatham County, the school systems are predominantly white, but yet the majority of the children that we see in juvenile court are kids of color. Somebody make it make sense to me. Somebody explain the numbers. I can't, but that's what we see. And so when I sit down and explain, to the parents, hey, I have 2 kids. Let's talk about this. That opens up the door for the parents to give me a lot more insight to what's happening at the schools. And then I try to use that information and give it to the court counselors and give it to the DAs and provide it to the judges to try to assist my client. So it's a delicate subject, but it is something that I think you do have to open the door, find a way to open the door to discuss, whether it's with your client directly or with the parents, but the door needs to be open to have that discussion.
Yolanda, I don't know if you saw, there are 2 questions in the chat. Are you wanting to do them as they come through or save them to the end?
I think we're going to save them to the end, although I think some of them may relate to what the next topics are. So I'll probably
Okay.
some.
Can I just add one more thing, Yolanda? I think sharing, and this is something that I have found helpful, not intentionally, but sharing what my experiences have been or how I feel. For instance, when a police officer gets behind me when I'm driving, I think people have this assumption because I'm an attorney that, oh, you're fine. You know what you need to do, But I'm like, no, I'm just a Black woman driving down the road. They don't know anything about me. And I'm sorry, this is my daughter who's in the room. They don't know anything about me. And I feel some kind of way. I feel nervous. I'm concerned. Anytime I encounter law enforcement, frankly, I mean, yes, I have a lot of experience. I've been working within the system for a long time, but I have those same anxieties. And I have talked to my white counterparts, the prosecutors, other folks that are within the system, and they are surprised every single time I say that. It's not just people who get in trouble that have a fear of law enforcement and have a fear of being in that situation. So I think also bringing that up, and I've said that in court too. If a police officer was chasing me and I didn't do anything wrong, I would probably run too. Those kinds of things. I just feel like it makes it not seem like it's operating in this vacuum of kids who are doing bad things that are acting this certain kind of way. That it's kind of this hurt that many people of color experience that translates into perhaps not acting the way that they should in certain circumstances. So.
Yeah, I think kind of takes us back to that original question of how do you practically address it? In this one, I will take a question from the chat because I think it just segues back into what everybody was talking about. But Melissa asked, how do I use my client's race as a part of defending them? For example, because of my client's race, it affected how they interacted with the police, like Liana was just talking about, specifically if they felt like they were not free to leave. So how do you use your client's race in that analysis, whether or not they felt free to leave, and in your direct advocacy there? I
think you have to put it out there. I think when you start the discussion with the district attorney, it's like, first of all, we're talking about a young man who's not, he's a person of color. So based on the age, they have experience of watching media, and seeing the stop, seeing people of color being killed, seeing people of color being abused by police officers. That these kids don't live in a vacuum, and that they have these everyday experiences where they have been in one form or another, have faced some form of discrimination based on their color. And you combine that together saying you need to think about this from this kid's perspective, not your perspective, not, especially if you're talking to a person who's white, ADA who's white. It's like, not from your perspective, because you don't know that fear. You don't know that, you don't have that fear of, if I get stopped, will I survive this stop? Based on what I've seen on TV, based on what I know has really happened. And you have to try to convince, or I won't say convince, but try to get your ADA or your judge, even your court counselor, to say, hey, I need you to look at this from my kid's perspective, not from yours. And that's when sharing your own experiences, if you're a person of color, sharing your own experiences could help. One of the stories which I still will tear up to this day when I talk about it, as a young 5 or 6 year old. My parents moved us into an pretty much predominantly white neighborhood. We were the first Black family there. And when I got off the bus, I had to have a race home, because if there's 2 kids in my neighborhood who, when the bus went around the corner, they would jump me and beat the living daylights out of me every single day. And I try to explain that to people, saying, I talk about it saying, imagine me, the 5-year-old, you see me now, but can you imagine me as the 5 or 6 year old who got beat up every day, called the N-word every day, just because I happen to be the only Black kid in the neighborhood, right? So I give them that experience to say, now look at my client. He's maybe the only Black, only 3 or 4 Black kids in this classroom, and we don't know exactly what's happening in that classroom. And he's experiencing all of this. And that's why when this one kid said the one thing to him too much, he went off. And you got to take that in consideration. So I share that story to say, perhaps the best thing you can do is to try to get whoever you're talking to look at the experience from your kid's perspective and that your juvenile's background.
So I would just kind of piggyback on that. So I think the question, and I'm happy to talk about this too. So we've had to actually do this in the sense of, and what Regina's saying is exactly correct. It's so like, we already have really good case law that talks about the reasonable child standard in the context of custody and interrogation, and that you have to look at the child themselves, right? It doesn't matter how everyone else feels. So when you're talking about a situation, and it sounds as though from the question, the situation really is also specifically to whether or not that child would feel free to leave. So you're basically going to just expand on that reasonable child concept and try to argue for a reasonable Black child concept, right, in front of your court. And so you're going to use the great case law that we already have on these issues, and you're just going to ask for like a tiny step forward on it, right? Is that you also take this into consideration because this is so important, and here's all of the reasons why. And there's a ton of resources that are put out by the Galt Center and Chris Henning's book, if you haven't read it. I mean, there's so much information and resources out there about how to take that next step. And I am happy to kind of talk through exactly how we argued it here in the custodial interrogation context also, if that is specifically kind of what people are looking for.
I would say, just to add on, the providing context, I think, the background, the circumstances, what was happening, because some things can seem like it just came out of the blue, and it doesn't, I guess, negate the bad behavior, so to speak, but providing some context for the circumstances has been very helpful in negotiation with the prosecutor, and even explaining with the judge as far as disposition goes. So if we're talking about, every kid doesn't have to be on probation when they get adjudicated, right? There's all kinds of different ways to handle it. So maybe if you want the child to be held responsible for the bad behavior, they got into a fight, right? But it was this kid that had been bullying them, and the school didn't do much about it, but the kid got beat up pretty bad. So, okay, we adjudicate it, but the disposition, why does that kid need to be on probation? Perhaps something like a pro-social activity, or perhaps doing community service. But I feel like that advocacy carries through all the way through, and providing the total picture of what's happening can help get better outcomes, even for your client, if they have to go through the court system. And so I think at every stage, you can be providing this context so that the judge is not just looking at this piece of paper and saying, oh, this sounds terrible, this, got a busted eye socket or whatever it is. This is what was happening. And I think it's hard in the face of that information to ignore it, hopefully.
Yeah, I think Chris Henning's book is called The Rays of Innocence, I believe. I think somebody may have just put it in the chat for me. Thank you, Persia. But he talks a lot about the reasonable Black child, and how, like Michelle was talking about, how that you use the child's racial identity and that reasonableness standard. Yeah, I don't think we can ignore our client's race when we're thinking about that standard, whether or not their personal background, the environment they grew up in, whether or not they had a positive relationship with police growing up, all of that stuff factors into that analysis. So I appreciate you all answering that question. How, just to keep going along with some of what we've been talking about, how do you think about race in the kind of pre-adjudication phase of the case with When you're thinking about diversion, I know that we have a little bit different in North Carolina in terms of how cases are diverted on the front end, but do you talk to your court counselors about race? Are you able to have any influence with cases that get diverted? And what's your experience there? I'll start with Audrina. Looks like you might be wanting to say something.
I'm laughing because so you can get numbers from your from juvenile justice, right? You can get the numbers to see how many cases have been diverted prior to, so not coming to court. And then I would say, as for those numbers, look at the race of those kids, because it sometimes requires you to have a conversation with your court counselors to say, hey, look at these numbers. Why are you have these kids? Why are they getting diverted and these kids are not? I think if anybody's been around me, you'll hear me use the term choose violence. Sometimes you just gotta downright throw stuff in people's faces and say, this is the way this looks. This may not be what you intend, your intention, but this is the way it looks to the outside world. And do you really want to put out this image? The reason why I'm bringing all of this up is that you're talking pre-diversion. So, if you look at these numbers and you see certain kids, they get these diversion opportunities and certain kids do not, call out your court counselors on that. Show them their own numbers. And then then they'll say, well, what the response I've received has been, well, we were trying to work with them and they weren't cooperating and the parents weren't cooperating, so we sent them to court. Again, look at the numbers and shove their numbers in their face going, well, how many times did you try to work with them? Did you talk to the family to see what else was happening in their lives? Maybe their mom couldn't get them there to the program. Maybe mom was trying to juggle 3 jobs, another kid, and a sick parent, and still trying to get this kid, to your diversion program. And it just wasn't working. It doesn't mean that this child didn't deserve the diversion. It doesn't mean that the family wasn't trying to cooperate. It means life was lifing. And these people couldn't, this family could not do what is required. So in choosing violence, I say get the numbers and shove it at your court counselors to say, especially if you see the numbers show that kids of color aren't getting the same opportunities, shove their numbers at them and ask them to explain their numbers, and ask them to look at what they're really doing. Even if they don't admit it right up hand, but the fact that you pointed it out to them, you might see some changes.
If I can add to that, one of the things that I realized a few years ago in working with one of my coworkers at the time, I would see her get these results for her clients, and she was asking for diversions on cases that I wouldn't have considered asking for. So it's cases where the kids had a prior history. I kind of made an assumption with assault cases. Like, there were certain things that I had in my mind that I'm like, they're not going to do a diversion for that. And I was sort of self-selecting the clients who I was advocating for, asking for a diversion. And I realized that I had a bias, and it wasn't, it was related to crime specifically, but also, to be perfectly honest, young Black males. When they were charged with certain things, I wasn't asking, not because I didn't think they deserved it, but I just didn't think the prosecutor would do it. And so I think we need to, as defenders, need to look at how we're moving and look at how we're choosing to advocate for the clients that we have. Never in a million years would I have thought that I had this bias, but it was sort of an unconscious thing. I was like, they're never going to go for it, so I never asked. And then I would see my coworker getting these results, and I felt terrible. Like, why haven't I been pushing for this? Obviously every case is not going to be something that's ripe for diversion, but really concentrating on the facts of the case. This is a stupid fight, or this is a trespass, or this, whatever it is, really examining those facts. And if it seems like, you know, let's look at the total, like that big picture here that we're going for, right? So there was a fight, it happened over this certain thing. I think we need to be better at digging into those facts and asking the prosecutor, is this really a case that needs to be on supervision by a court counselor with everything else that they got going on? Can we just resolve this, come back in 3 months, my client hasn't been in trouble, maybe they'll do some community service, write an apology letter, and then we don't adjudicate it. Or if they really want someone to be held responsible, we can adjudicate it, but then enter no disposition. You know, I think that we need to be more proactive and think outside of the box at the pre-adjudication stage, because the more we keep our clients out of the criminal justice system, the less likelihood they are to continue to encounter it over the years, right? So I just challenge you all, and I say this because of my own personal experience, to look at how you're asking for diversions. I know people, probably not intentionally, you know, who are on like the court appointed list, and for clients that they're getting paid, you know, they were retained by clients, and I'm sure it's not an intentional thing, but I feel like the advocacy could be a little bit different there. And that should absolutely, of course, we know, not make a difference. But I just challenge all of us to really think about when we're asking for those deferred, because I think we could be getting a lot more cases not coming into the system if we just simply ask. All they can do is say no.
Thanks, Liana. Michelle, did you have anything you wanted to add to that particular question?
Well, I do feel so. I love everything that everyone's already said. And DJJ and DPS, a lot of times they don't have their current data book up there, but they do put their data books on the internet and they're accessible to everyone. I think 2022 is the last one that's up there, but that's going to show a lot of your demographic information from your counties. And then it's also going to show how many filings, how many different levels of charges and things like that that are coming out of those counties. And so that's always been a really helpful resource. And Mecklenburg County, we really don't see a lot of the low level offenses. And I do think that that's the benefit of having court counselors, court counselor supervisors, and a chief who is in touch with the community and who are men and women of color who are much more in touch. It also does create a situation in our county where when I come to them and start trying to argue these issues, they will quite frequently say, Michelle, stop, right? We try, we do our best. You're being a little bit too much right now. And so you kind of do have to be prepared for your audience and where you're making those arguments and when, you know, they're going to toe the line a little bit and tell you that they've had enough of you for the time being. But then you have to pick yourself back up and, you know, go back into the next kid and try it a different way, because the reality is that what we are saying as defenders is the truth of our clients' experiences. And it doesn't actually matter who your audience is, but it is our job to figure out a way to present the information that it's going to be accepted.
That's helpful, Michelle. And just I know that there are a couple of questions about where to get that data, and just emphasizing what Michelle said, that DJJ publishes a database annually, and like she was saying, 2022 is currently up there on their website. DJJ also has a person on staff who focuses on this type of work. Her name is Crystal Wynn Lewis, and she's very great, but she will often help you get specific data to your county, and it works a lot with the Juvenile Crime Prevention Council. If any of you are a part of that in your particular jurisdiction, a lot of times they're able to get the red data for their area, and you can look at some of the numbers specific to race. I do want to take some more time for audience questions, but just because this is one of the questions that I had for the speakers, I'm going to combine two questions, and Michelle kind of ended with this, but how do you change your advocacy depending on the audience or the race of your court actors? And so you guys have talked about this a little bit more, but I just want you to expound upon it a little bit more. If you are a Black attorney with dealing with mostly white court professionals, if you are a white attorney dealing with white court professionals, how does the race of your audience dictate how you advocate for your clients in these situations. You want to start with Liana this time?
Okay, I just want to make sure I understand your question. So you're asking, say it one more time. I'm sorry.
Yes. How do you address race with white court actors, and how do you address race with court actors of color? Does it change the way that, does race of your court actor change how you advocate?
So the short answer is sometimes. I mean, it really depends on the situation. I think as best I can, I try to cultivate strong relationships with court counselors. I've had court counselors say to me, kind of off to the side, this is BS. Like it shouldn't have gone this far. And they kind of give me the heads up. Honestly, a lot of the time, so that I know that there's something, something awry. But I think it depends on the case and it depends on the circumstances, just like anything else. So I know that's not maybe super helpful, but I think when I'm talking to you, depending on the person, if it's another person of color that I'm familiar with and I have a prior relationship with, there is sort of a shorthand that I could say, explain kind of what's happening with my particular client. Oh, it's this type of situation. If it's a white court actor that I have a good relationship with, honestly, the conversation will be sort of similar. So I think it's more dependent on my relationship with the person than it is on the race of the person, frankly. But I think if I was walking into a situation that I didn't know anyone, then there would definitely be a different presentation, I think, to a white audience than to a Black audience, for sure.
How about you, Wadrina? Thank you, Liana.
I'm going to follow up with the comment about developing relationships with your court actors, in your particular district, jurisdiction. You don't really have to do it, and it's really not the right time to do it in the courtroom. Have those conversations about race issues with your ADAs, with your court counselors, that drop in, can we talk? And just in general, have those conversations with your judges. We all have those quick conversations with the judges. Hey, how you doing? And you can say, well, Judge, last week we had this case. Let's talk about some factors, or let's just talk about race things in general. That what has helped me over the years. Just having general conversations so that when I bring it up in court, I have laid that groundwork. That they understand where I'm coming from and why I'm bringing this issue up. And I will say, I will have to agree that depending on your audience, sometimes you do have to change your angle. As I was saying earlier, race may not be the first thing I bring up with my audience is predominantly white. I might wait a little bit before I bring it up. So again, they won't say that here's just another Black person talking about the race card. And even if the audience is people of color, at the same time, and I'm going to put this out here, at the same time, there are some people of color who say, well, we use race as an excuse too often for behavior, for bad behavior. And, say, well, hey, I grew up in the hood, and it's a matter of making choices. I didn't make those choices to do those things. So don't use race as an excuse for bad behavior. So you have to know your audience and kind of get a feel for when do you bring it up. But that still kind of goes back to relationships and who you're talking with, and have you developed a good relationship to bring the concept up with the person you're speaking with.
Thank you, Wadrina. Michelle, did you have anything else you wanted to add?
So I think, I mean, I feel like it's been covered, but I do think one of the things that can be really helpful is, so Mecklenburg County established like a full group of court professionals called Race Matters for Juvenile Justice. And there's prosecutors, there's defense attorneys, there's judges, there's court counselor representation, there's child services representation, and it's essentially all of the leaders within the courthouse that meet and talk about these issues pretty openly with each other. And it just really allows for this open exchange of information or perspectives and feelings in an environment that isn't confrontational, because it's outside of the courtroom. And part of that is also that any professional that's practicing at, Council for Children's Rights or at the Public Defender's Office or at the District Attorney's Office, CMPD, the sheriffs, we all agree as organizations that are part of RMJJ to go to this intensive 2-day training that kind of teaches everybody about the issues specifically in Charlotte that have gone on throughout history, as well as kind of what we see inside of our courtrooms and implicit and explicit biases. And so that is something that as a community of stakeholders, you can come together and establish, which does kind of help these conversations flow more smoothly, hoping everyone's on the same page as you are presenting your cases and you're arguing these things inside of the courtroom.
No, I think what everyone has said has been very helpful. And I was just going to emphasize, I think relationships, working with different stakeholder agency groups in your county sometimes are where I would say, I feel like a lot of the organic conversations happen. A lot of times people are going to feel a lot less put on the spot back in their office talking about these issues, or than like what Gina was saying in the courtroom at that time. So I think, again, all of that's very helpful. The last question I'll ask before I go back and go through the chat questions is, we talked a lot about data, where to get it from and kind of what data is useful, but what are some practical ways to use data in your advocacy? Is it in the courtroom? Is it on with some of these different work groups with your JCPCs? How can you incorporate this data into your advocacy? And I will start with Liana.
So I want to do a better job of incorporating data into my practice. I feel like probably like in presentations, things like that is where I've used it before. And maybe in specific cases, I think it's more anecdotal, what my experiences have been. So it's not data that's been pulled from DJJ or any of those places. It's more so kind of an informal, I guess, number that I've kept track of, or like I was saying earlier, we're getting referrals from the same teacher, from the same SRO. And so it's not data per se, I'm not talking numbers, but it's just a repeated pattern of behavior that I think is indicative of an issue that's happening. So I think sort of informally, that is a way that you could use it, but absolutely, I think pulling the data, I will say that, I guess in terms of percentages, maybe Rodrina was mentioning this earlier, this school is 90% white and 10% Black, and 90% of the referrals are for the Black students. There's an issue there, right? So I think making statements like that, honestly, if it's that egregious, I feel like fortunately we're usually able to resolve it on the front end, and that's sort of the pre-adjudication advocacy where that can be very helpful, is meeting with your client, getting that information, and sharing with the prosecutor, those specific things. I feel like if it is something that is a systemic problem, I'm not saying we do a great job of always resolving it quickly in New Hanover County, but I feel like if it does turn into that, then we're usually able to address it, because frankly, they don't want it to go to court and be embarrassed in court. But I will take all the tips as well from the other folks here, because I think that is a pretty persuasive thing to use, potentially at bond hearings, at detention hearings, things like that. So.
I think that's helpful. Yeah, especially, I do think it's sometimes just hard to go into, you just give them a report. So it's good to think about ways to either distill the data down into the percentages, like Liana was saying, use it in your different hearings. I'll go to Michelle next.
So we're interestingly situated in the Council for Children's Rights because we actually compile our own data. And so our organization pulls the data for all of the delinquency cases, and we also represent any child in involuntary and voluntary commitment hearings in Mecklenburg County. Well, if they're in a facility in Mecklenburg County. And so we have a lot of data. And I know how many kids are getting diversions. I know the demographic of the children who are getting diversions. I know how many dismissals there are. I know the demographic of the kids getting dismissals. But what's more interesting is I also know which children who are exhibiting the exact same behaviors are landing in delinquency court versus mental health court. And not to the surprise of anyone probably on here, but the young Black child who is exhibiting the same behaviors as a young white child, one will be funneled into the delinquency courtroom and one will end up in mental health court on these involuntary and voluntary placements. And that has been the data actually that has been the most effectively used for our organization. And we've done that in conversations at RMJJ or in presentations in the community, in conversations with the school systems, because a lot of times that those types of behaviors are starting to come up in the school systems. And so we can start having that conversation earlier on using that type of data. And so that has been incredibly helpful and almost even more helpful than just holding the delinquency data alone. Because some of that, if you're in a county like ours where the amount of children being charged are overwhelmingly children of color, your data isn't necessarily going to show that bias or discrepancy that you would expect. But where we do see it is when we compare those two systems.
That's helpful. And I think a good way of demonstrating how you kind of can take that data and then go to the community through presentations, through trainings, through your local bodies to then impact a direct change. Madrina, last but not least.
I was going to say the same similar comments. Use that information when you have the conversations outside of court, not just inside of court. When you have those conversations with your judges, with your ADAs, with members of the community, and you use the information and you basically say, please help me make sense of this. Let's call out our leaders. Let's call out the school boards. Let's call out the principals about this information and have them explain it. Better yet, let's have the sheriff's office explain why the school SRO only, the numbers show that these are the cases that are being referred to CJJ. So I agree with what everyone has said previously, that let's use the information and use it outside of the courtroom and not just in the courtroom.
Well, thank you, everyone. Yeah, I think using it outside and inside, I think that's a good kind of message to take from it. Is you can utilize it in different ways, but a lot of the work honestly does happen outside the courtroom, especially when it comes to data usage. Okay, so I want to go to the chat, and there is a question from Berja, and she says, this is a question thinking about cultural backgrounds. She said, do any of the panelists have experiences representing specifically Hispanic youth who may have had a different cultural background? And if so, how do they approach it? So how do you approach or deal with different cultural backgrounds in your advocacy, and how do you explain that to different court actors? Feel free, anybody who wants to jump in to start.
I would start try to learn the culture. That's again, Orange County has a lot, but Chatham County, we have a lot of Hispanic youth. And one of the things that I have tried to do is I go and participate in various cultural fairs to learn, to understand. Heck, I've had a few clients invite me to their houses, and I'll show up. I'm like, okay, y'all having what? Okay, tell me. I'll be there on Saturday. I'll show up to the family function just to understand and just to learn, because it does help you advocate for your clients better when you do understand, their background, their history, their culture. And the only way you can, well, I can't say I completely understand it, but by participating in culture events and encouraging my clients and their family to invite me to cultural events and actually show up, and they see that, oh, wait, my attorney showed up to this. Yes, because your attorney wants to understand and wants to know more. And then I get further in, more invitations. And the whole point of that is for me to learn and for me to understand as much as I can understand. And it puts me in a better position to be able to, again, advocate for them when I'm speaking about my client and their culture and their background, when I'm talking to judges and when I'm talking to ADAs and court counselors about it. But again, that's my approach. Not everybody wants to get invited to the cookouts.
I would say that I haven't had an experience. I haven't personally had an experience where I've had a client that, because of cultural differences, thought something was okay that in America is not okay. I haven't had that particular experience. I have a colleague, and it wasn't a delinquency case, it was a DSS case, where there were a lot of actions that took place in Mexico related to a child that were used against the mom here, and which was a very interesting position to be in. So it's not related to this question, but what I would say about dealing with Hispanic clients, with some Hispanic clients, what I have experienced is language barrier for sure. I would say with probably 70% of my Hispanic clients, my client usually speaks English, but their parents don't. And I think that their cases have made it to court sometimes because of the lack of communication when they were trying to divert it. And so that is kind of where I see it. And then I try my best to send it back to be able to get it diverted, kind of explaining more about the process, so that the parents have an understanding, like if you do this and then it'll go away. But that really has been my experience, not necessarily, not like, this is fine to do in Colombia, but you cannot do it in America. I've not had that experience.
So I 100% agree in the cases that don't get diverted. Sometimes I do believe that it was a language barrier and that the Department of Juvenile Justice was not using an interpreter appropriately. And so that's where the breakdown happened. I've had a lot of experience representing clients from different backgrounds, having come from Jamaica, Queens, which is one of the most probably diverse boroughs in New York City. And so I think across the board, one of the most important things is to listen, right? Like, I am very conscious of what I don't understand. It was one of the first things that I was taught when I walked into the office in Queens, was to understand what you don't understand. And so I think you have to listen to your client. And since I've moved here, a lot of where this has come up inside of our courtrooms is our young, male clients who have taken on the responsibility of providing for their families here, whether they are undocumented or they were born here, but their family wasn't. And so they've taken on this role in trying to navigate educational services and our court's extreme focus on education as a condition of their probation or a condition of their release, and then trying to navigate how to explain that, yes, that is a priority, of course, but this child is dealing with this other issue that is the priority for them right now. And I think that spans not just, clients of a Latinx or Hispanic background. That's going to go for all of our clients who are just differently situated than what a lot of our judges are familiar with, depending on who you're arguing in front of. And so I think you're navigating those types of issues really frequently with clients who are coming from different backgrounds and different life experiences, and just kind of reminding your court partners, or reminding your judges that their perspective on the world and their lived experiences is not the same as your client's lived experiences. I think the more your judges hear that, the more likely it's going to be that they start thinking about that when they're hearing their own cases.
And can I add, I think to me, like the bottom line of all of this is personalizing our client's case as much as we can. So like learning as much information about our client, what they like to do, if they're involved in extracurricular activities, or if they're not. I mean, sometimes, you're asking clients, what do you like to do? And it's like pulling teeth, but they like to play video games. Okay, well, what do you want to do with that? Do you want to go to school? Do you want to pursue whatever? I think the more we personalize and humanize our clients, it's a shame that we have to do that, but especially our clients of color. I think it's so easy to group young Black boys into a group that's like no good in some people's eyes. And so the more you individualize and personalize your client, my client loves video games. He dreams of being a video game programmer. You start talking about those things, and you are reminding the court that these are children and that this is an individual. And it's, I hope, harder to group folks together when you feel like you're knowing them a little bit. And so, if you're thinking of practical things to take away from this, that is something that we all have the ability to do. It's frustrating if you can't get in touch with your client ahead of the court date sometimes. So maybe that morning you're huddled up and you're trying to get this information about your client, but talking to them and sharing about who they are to the judge, I feel like that is really what we can do. Sharing who they are to the prosecutor before it even gets in front of the judge. Just personalize it as much as you can. And I think that's the way, hopefully one of the ways that things can start changing, and people can stop being grouped together, assuming that everyone's experience is the same, everyone behaves the same.
I think that's a good point, Liana. I think Eric had a question. I think you muted yourself. Yep, there you go.
I think, as folks know, we're currently building a roster to have attorneys represent 13 through 17-year-olds charged with first-degree murder. And as part of that process, I've worked with DJJ to get specific data. And the numbers, as bad as the numbers are in other sectors and other procedural points, what we found out was that 93% of all the youth charged with first-degree murder, 93, that's a 9 and a 3, are persons of color. And, specifically with these youth who are facing the most serious consequences, I didn't know if the panelists had any thoughts, on this, and either raising race or in your communications, your negotiations with kids charged with the most serious offense, facing the most serious punishment. Any thoughts about the intersection of race and these particular youth?
Eric, I always have thoughts, feelings. Come on now. That's actually a very sad statistic. Let's just start off with that. It's a very sad statistic. My most immediate thought is that we have to look at the bigger picture, not just they're charged with murder and the most serious violent crime there is, but look at the bigger picture as to what's happening in these kids' lives, these juveniles' lives. How did they get to that point? What is going on, in their lives, their family background? Let's take in poverty, into consideration, education. And I think what it does is open up a bigger discussion of what is leading these kids to be in situations where they can even be charged, and what's happening with them. Yeah, I could get on a soapbox here, so I'm going to stop and not get on my soapbox. I see y'all are taking bets. I see you on my frame over there, and see y'all are taking bets if I'm going to get on a soapbox. But I'm not going to get on a soapbox. I'm just going to say it opens up a bigger discussion for me about what's really happening in general to across the state, across the country, to kids of color and their families and what they have to live through. It goes, we can talk about the housing gap and affordable housing. We can talk about income. You know, I was on a discussion yesterday where the gentleman said that a person of color, a Black person who could have a college degree, was more than likely to have, because of racism, was more than likely to have, I think he was quoting as saying, more issues related to health, or actually live less. Their life expectancy was less than a white person who only had a high school degree. And he was basing that on racism. So your question, your thoughts really, Eric, talks about a bigger picture, and I'm not going to get on that soapbox too much. I got on it a little bit, but we are talking a bigger picture here. But for me, what it boils down to is that we really just have to start addressing the issue of racism in this country and show how it affects the effects of it on families, and how it trickles down in the families to the kids and what we get. I'm getting off my soapbox now. Eric, I believe you set me up. Thank you.
Any further thoughts from either Michelle or Liana? It's okay.
I'm gonna go ahead and guess that of that 93%, a decent amount of them are sitting right here in my county. And so I think Regina's soapbox is important. And I heard what she, if you listen to what she's saying is right. This isn't happening in a vacuum. Even if you look at the cases in Mecklenburg, and if you look through the history of the children that we are seeing coming in on this level of charge, you are seeing failure after failure after failure after failure after failure of the community, and that is how they've ended up with us. And it certainly doesn't do us any favors that the legislature changed the statute, and now they can just indict those children who are under the age of the mandatory transfer and not even give them a probable cause hearing any longer, because based on our experience in Mecklenburg County, a lot of times they're not able to prove that. And so now those children are going to go and sit in adult court indefinitely as well, waiting for their trials to happen. And so we are certainly not doing anything to stop perpetuating the cycle of what we see in our communities. And that is incredibly disheartening as a member of the community, and I'm sure for everyone else who is a juvenile defense attorney on here.
I guess I would just add that I think there's a hopelessness in a lot of the youth that we work with. And I think it's hard to value other people's lives when your life is not valued. And that's sort of drilled into your head every place you go. I'm curious if the victims of that 93% are also people of color, which I would venture to say it's probably a high percentage that are the victims are people of color. And I don't have an answer for that. other than, like everyone else said, which is dealing with the underlying problems that drive people to be so hopeless, to not care. Why taking another person's life? It doesn't matter in the scheme of things when you don't have much to look forward to. You don't have a lot to lose. So.
I noticed, I think Berja has a hand raised. Or...
Yeah, it's actually Eric has his hand.
Okay.
So I really appreciate everybody's response. I just want to say this very quickly, that yesterday, and you can check it on WRAL.com, the Conference of District Attorneys came to the General Assembly to a committee meeting to talk about the changes they wanted to make and raise the age legislation. You know, they're always very concerned about those youth charged with the most serious offenses. You know, this discussion about these kids is about racial justice, and like nobody's willing to say it. But I know the prosecutors are thinking about this and thinking about these kids, and however people think it's appropriate and effective in their representation, especially youth charged with serious offenses and are facing transfer, this is on the brains of the opposition. And as if we know that ahead of time, maybe we can use that to our clients' advantage, like everybody was saying, individualizing and telling their stories and placing it in a context. But it's very disheartening on a policy level to see this argument continue. It really is. So I just wanted to put that out there.
I know we have reached the 2:16 mark, and so I understand that people have to pop off, but I did just want to acknowledge one question. Eva Lee has been talking in the chat a little bit about scouting diversion programs, and I think she's left some helpful links in there about different programs in other states, I think. But if any of the panelists can speak to a little bit of if you've seen any scouting diversion programs in your community, I will just for help a little bit. A lot of our diversion programs are run through the Department of Juvenile Justice and are allotted county-based juvenile crime prevention councils, allot funds for different local programming. But I will let Regina expound upon that a little bit for you, Eva.
I was just going to say that I think for it to qualify for funds from JCPC and other grant funding, the diversion programs are the programs that are developed have to be evidence-based. And so you have to be able to show not just, as I put in the chat, my kids are 2 Eagle Scouts. So, and I'm a big fan of scouting, but to create programs, diversion-based programs, you have to have it evidence-based, and it has to meet certain criteria to get the extra funding. So it's not something that I would say is easy to come up with. You got to put the program together to get it approved for it to be considered as a program that they could send kids to as a form of diversion.
I think though that what you're speaking of, and I meant to say this earlier, the JCPC, so it's the Juvenile Crime Prevention Council, and every county has it, or every district, I guess. I think it's every county has a JCPC. I've sat on mine since I joined the Public Defender's Office back in 2010. If you're interested in developing programs like that, JCPC is comprised of members of the community. There's usually a defense attorney, prosecutor, DJJ representatives, programs that get funding from JCPC. They participate as part of the meetings. It's usually once a month. I think we meet maybe 9 or 10 times a year. I can't remember. There's usually a break in the summertime. But if you can figure out your local JCPC, I think as defenders too, it's helpful to know and learn about the programs that are available in your county. So if you want to try to advocate for a diversion or an alternative disposition, it's helpful to know the programs that are available. And most counties have, well, I won't say that. So there's lots of great programs in a lot of different counties, but you can just look up, your local JCPC and find out when they're meeting. The meetings are open to the public. And if you're interested in serving on it, they do have members at large that people can apply for. I think it has to be approved by the county commission, but so there's a process, but you can attend the meetings and at least learn more about it. But I encourage defenders to go because it's interesting to learn about what is out there in your jurisdiction.
Thank you both. So I'm going to just ask one concluding question. And again, I thank you all for your time and for being here today, everyone attending, and especially to the panelists for taking time out of their schedule to do this for us. As we know, especially working in this field for a while, sometimes racial equity work and racial justice work can be tiring. How do you stay motivated? Do you have any words of wisdom for defenders throughout the state on how to keep pushing even when sometimes we're not seeing the needle move as far as we would want to see it? And anybody jump in to start?
I would say that for me, participating in trainings, helping talk to people across the state and in other places, that helps sort of keep the fire going for me, being able to talk to other folks involved with the system. I also feel like it can be overwhelming thinking of all the people that need help, all the injustices that are happening every single day, every single second, it feels like. But I try to remember that if I'm helping one person, one person a day, one person a week, making a difference, that collectively over time will help. And so I try not to focus on all the people that I'm not able to help. I try to focus on the people that I can help. And if that means keeping one kid from being adjudicated, that's making a difference, that's helping them. Personal ways and self-care. I mean, I have to say that I don't like watching movies where people of color are being mistreated. That's like a boundary that I have now. I've watched a lot of movies like that, and I just can't stomach it anymore. I don't like watching movies with slaves and things like that. That's kind of random, but that's a self-care thing that I do for myself. I'm not saying those movies aren't important, and there's plenty of people that should watch those movies and need to be educated. I'm not one of them. But I think remembering that one person that we can help makes a difference.
I will just sum it up with keep talking about the issues. Just whether it's formal events like this, informal conversations, but keep talking about the issues. And, what motivates me, I actually put this on my Facebook post the other day, and it basically says, and if I arrive at my grave leaving at least one soul better than I found them, then I will consider my life a life well lived. And that's what keeps me going. That's why I get on my soapbox. But thank you everyone for participating.
So I don't think I get to be tired. I think that, as a supervising attorney who has attorneys on their team who are people of color, who are, having to do discovery involving police officers, treating our clients in a particular way, or, making these arguments themselves in court, I think that I can handle this because there's a lot of people who are handling a lot more, and that includes our clients. And so that's kind of the way I approach it. And I do think that my job is to tell their story and not my version of their story. And I think that that is the most impactful thing that I can do, maybe even sometimes more so than getting the results that I want for my client or my client getting the results. Sometimes my client needs to have somebody who stands next to them and tells their story. And I think that I remind myself that that is what I am doing. And that is how you survive doing it day after day after day after day.
Thank you all. I think it's helpful for me to hear, and I think helpful for all of our defenders too. Well, I think we have reached our time, and I'm sorry that everyone went a little bit over, but I really appreciate all of the comments from our presenters, our panelists. I think I can speak for myself that I learned a lot, and I know